Laws governing the contracts involving sale of goods or lease of goods fall under the Uniform Commercial Code or some version of the Uniform Commercial Code. State statutory law governs. Each state has its own version of a commercial code, but the Uniform Commercial Code was developed to allow or to be a source for people involved in commerce. The goal of the Uniform Commercial Code was to simplify and streamline commercial transactions. And generally, states have followed this Uniform Commercial Code, but as I said, each state will have some sort of version of the code. And transactions involving leases or sale of goods are governed under one section or article of the Uniform Commercial Code. The sale of goods is governed under Article 2. Lease of goods is governed under Article 2A. The language it mirrors, except in Article 2 they use the word sale, and in the Article 2A they use the word lease. But the UCC itself governs all sorts of commercial transactions. Some of the stuff we're going to talk about later in this semester. Article 3, negotiable instruments. Article 4 is banking. Article 9, secured transactions. So we'll talk about more articles of the UCC. Let's start with sale. What is sale? What is a sale? We kind of all had a sale or been involved in a sale. Maybe we were the buyer. Maybe we sold something at a garage sale on Craigslist. What is a sale? It is the passing of title from seller to the buyer for a price. Well, what's title? Title refers to the formal right of ownership of property. So I have a title to my car, I have a title to my phone, my smartphone. Title doesn't necessarily mean it comes with a piece of paper, right? I mentioned car. If you own a car, you have a piece of paper. It's called a title. In some states, like in New York, you actually have and hold that title. If you owe money to a bank because you've had to get a loan for it, at the bottom of that title, it'll have the name of what they say the lien holder. We'll talk more about that when we get to secured transactions, but there are some states where you wouldn't even get the piece of paper. It would be held by the actual creditor, but nonetheless, you still own the car and have rights to sell it and so forth. So title refers to the formal right of ownership of property. What is price? Well, it's the cost. Doesn't necessarily mean cash because, we could trade. We could trade for other goods. We could trade for other services. So what is price is not necessarily cash number. So what are goods? Because we're talking about the sale of goods or the lease of goods, and we'll get to lease in a second, but right now we start with sales. But goods. The UCC actually has a definition for goods, defines goods as all things which are movable at the time of identification to the contract for sale, other than the money in which the price is to be paid. The money doesn't constitute the good, that's the price, right? Also, securities aren't considered goods. So let's go through some examples here. So let's say Hector. Hector has an exercise bike that he never uses. Cleo has been given an expensive hammock that she doesn't use or want, and they agree to trade. This transaction would technically be governed under the UCC. Sounds simple enough, but it's a transaction for goods. We have one person giving a specific good and trading it, somebody else trading their good for the other good, right? This transaction will be governed by Article 2. Different example. On the advice of a number of friends, Annie visits her local bookstore where she buys a copy of a book. It's the next Harry Potter installment. This is going to be governed by Article 2. It's a sale of goods. This might be kind of obvious. You go into a store, you pick up an item, and you purchase it. You're buying a good. The book qualifies as a good. Another example, because the amazing demand, the bookstore runs out of the Harry Potter book and must contract to buy a large number of copies from the publisher. Is this transaction covered? Yes, it is, right? Because the transaction between the bookstore and the publisher. The books are still considered goods. What if the publisher informs the store that all previous printings of the book have been completely sold out and that it will fill the order only when later printings come? They come next month. Do we still have an Article 2 case? Does it change your answer? No, no. We still have an Article 2 case, right? This is goods. They're not existing, but goods which are both existing and identified as future goods. We're going to say future goods are considered goods because we know what we're looking for. We're getting the book when it comes, right? How about this example? Author of the book, J.K. Rowling, who's hired to give a series of lectures and speaking engagements on the book by an organization in New York City. Is this transaction governed by Article 2? And the answer would be no. Why? Because her giving a series of lectures isn't a good, it's not something that's movable at the time of identification of a contract. This arrangement, this type of contract would be governed under common law rules. We're not going over common law contract rules in this particular case. I teach common law, contract common law in ACC 351. You have if you didn't take that class, you took an introductory business law class at another university or college, and common law contracts is one of the topics that is definitely taught. So I assume you come to the table with that knowledge of common law contracts. If not, you can review the chapters in the book regarding common law contracts. But this would be a service contract, and it would not be governed under Article 2, the J.K. Rowling's arrangement. So to be characterized as a good, that good must be tangible, something physical in existence or will be physical in existence, i.e. future goods that are movable and can be carried from place to place. So speaking arrangements, stocks, copyrights, patents, bonds, these are all intangible properties. These things can't be touched. They only exist conceptually. And these are not governed under Article 2. It's only tangible goods. So for example, J.K. Rowling holds the copyright in her book. She enters into a contract with a movie company to make a movie of the book, giving the company the right to use that book. This transaction not governed under Article 2. This is something I think is pretty important. Here's an example. Wimpy goes into a local diner and orders a hamburger, some fries, and a drink, and dines there. And the question is if something happens with this transaction, do the laws of the UCC Article 2 apply, or is this a common law case? And some folks might say, well, it's service. They're dining there, somebody brings them their drink and their food, and that's a service. But on the flip side, food, drink, hamburger would probably fall in the definition of goods. And then what if instead of going in, decides to go through the drive-through and get that meal? Is the meal then an Article 2? So there was some confusion. Courts were different whether or not food, if you're sitting down, if it's service, it's going to be under one particular body of law. And nonetheless, legislators have passed laws that basically said food is a good under UCC, whether you get it through a drive-through, takeout, pickup, or you sit down and you are served your food. It's going to be governed under Article 2 regardless. Moving on to goods associated with real estate. What is real estate? We'll talk more about real estate law and real estate, but for this purpose, real estate is land. Any interests in land, like an easement, you give somebody a right of way. Also, Things that are permanently attached to land. Trees, plants, sheds, house, barn, garage, all of those things are considered real estate. So I decide to move out of my rental apartment and move into a large home. I enter into an agreement to buy a house at 789 Widget Lane in Plattsburgh. Is this governed by Article 2? No. Real property is not movable. So this is going to be governed under the common law. Okay? You can't move it. It's attached, permanently attached. Remember, our goods have to be movable, be able to move from place to place. So for example, my new property includes a large wooded lot, and as part of the transaction to sell my house to the buyer, we also agree that the trees will be logged and cut and the wood sold prior to the sale, and the price reflects this. Is this contract for the sale of goods? And the answer is going to be yes, for the timber, right? Trees, they're permanently attached. If the trees were going to come along with the property, that's going to be real property. Transaction's not going to be governed. But when we start to remove things, contracts involving removing things from the real estate, timber, minerals, gas, oil, water, any of those things, once they are extracted or severed from the property, they become property that is now movable. So those transactions would be governed under Article 2. So what happens if a contract is for both services and goods? We can have contracts where we have both of these involved. Well, the UCC does not govern this situation, so the courts are the ones who decide what happens. So let's take this example. This is the example we'll work with for our rule. So we have Bigelow decides to fix up the kitchen in his bungalow. He enters into an agreement with Hammer for the construction and installation of a new set of kitchen cabinets. The specifications call for a particular type of knotty pine and designated brass handles and hinges. The agreed upon price is $3,000, which covers all the materials and labor. And the question is this contract governed by Article 2? Well, we have a couple things happening here, right? Because we have the agreement to do the construction and installation of the set of kitchen cabinets. So the installation agreement portion here is a service, right? So that would not, if we're reading this, let's pick it apart. That wouldn't be covered. But then we have the knotty pine and the designated brass handles and hinges, and those are goods, right? So is that Article 2? So what do the courts do with this? What if there's a problem with the construction? Because something could happen with the construction. Or what if something happens with the brass handles and the pine, and we have to go to court and fight over this? Well, the courts have said that the predominant factor test is going to be applied to each. We'll be looking at the face of the contract, and they ask the question, this predominant factor test, the question is whether the transaction was predominantly for the sale of goods or was it for the service. So back to Bigelow, he's decided to fix up his kitchen in his bungalow, and he enters into an agreement with Hammer for the construction and installation of a new set of kitchen cabinets. That's his end goal, right? That's what this is all about, is him getting a new kitchen cabinets for his kitchen. The specifications call for these good items, the knotty pine and the designated brass handles and hinges. So the courts would look at that transaction, and despite what issue arises out of this, whether it's the service or for the knotty pine, the courts are going to say that transaction was predominantly for the construction or the service. So we are going to apply the common law to this transaction, even if the problem arises out of, let's say, the brass handles. The courts are looking at the contract as a whole and determines what's it predominantly for. Lease of goods. Let's tie in the lease of goods. Up until this point, we talked about what a sale was. We talked about what goods are. Let's talk about the lease, right? Consumers and businesses love to lease items, whether it's automobiles, industrial equipment. There's many types of goods that can be leased out. Many airlines rent out all or if not most of their planes. Major manufacturers regularly enter into multi-million-dollar leases for massive pieces of machinery. We got consumer leases on cars. Small businesses lease office equipment and furniture. So what's behind the interest in the lease of goods? Tax consequences. The modern business environment likes leases. So Article 2A governs leases. It's fairly a new area of law, 1987, which was amended in 1990. So it's, like I said earlier, a repetition of Article 2, except they use the phrase lease of goods versus sale of goods. So what is a lease? The UCC gave us a definition, defines it as a transfer of the right to possession and use of goods for a term in return for consideration. You should know what consideration is. That's a concept that was taught under the common law. I'll get back to consideration briefly here under leases, but you should know what the consideration is. I call it the stake in the game. Each party has to have a stake in the game. Under a lease of goods, the lessor is the one who transfers the right to possession to the lease. That's their stake. And the leasee is the one who takes possession of it and uses the leased goods for a price. The price is their consideration. Who is a merchant and why it matters? Article 2 governs the sale of goods in general between all buyers and sellers, each and every person selling and buying a good. Buyers and sellers of goods are all governed by the UCC provisions simply because of who they are. They buy and they sell goods. So for example, you may not think of yourself that way, but let's say you're a buyer of a taco at Taco Bell or you buy a book at Target. As I said earlier, these transactions are governed by Article 2. You can be a seller selling something on Craigslist, on Marketplace, at a garage sale. If anything goes wrong with that transaction, the laws of Article 2 are going to govern. But there are special rules under the UCC for some unique set of players. We call them merchants. And there is no guesswork involved in deciding who is a merchant because I think the code specifically makes it clear. A particular statute is going to use the word merchant if the law is going to apply to them differently than just a regular buyer and a seller. So we don't need to decide whether in a particular situation someone we think is a merchant. We have a definition. It's in the UCC, and that entity or individual will fall under that definition. So who's a merchant? Well, the UCC defines a merchant as a person, and it could be a business, right? Best Buy, merchant. UCC defines as a person who deals in goods of the kind involved in the sales contract or who by occupation holds himself or herself out as having knowledge and skill unique to the practices of goods involved in the transaction. Now that's kind of a mouthful. We're looking at a contract and we are looking at what that person deals in. A used car salesman, right? A used car lot. They're going to be considered a merchant because they deal with goods of selling used cars. That's what any so you enter into a contract with a used car salesman, you're buying a car. We also can look at that person as holding themselves out. Are they specifically acknowledging that they have knowledge and they're putting it out there in a skill unique to the practices or goods involved in their transaction? So let's take a couple of examples. Let's say Ned's a lawyer and he's a proud owner of a purebred female Cocker Spaniel that he arranges to have mated with a purebred male owned by a neighbor. When the puppies are born, he posts a handwritten "Puppies for Sale" notice on bulletin boards around town and places a small ad in a local paper. Josie contacts him for a puppy, makes an agreement to buy the puppy for $500. Is this transaction governed by Article 2? Yes. Sale of goods. Yes, puppies are considered live animals, I should say, are considered goods, even if the agreement was made before they were born. Like the female puppy was, the female Cocker Spaniel was pregnant for the puppies, and you made an arrangement before they even happened, right? Future goods. So live animals are considered goods. The question is Ned a merchant? And the answer would be no. Right? He's not. He's a lawyer. He has a female dog. Hey, he wants to breed her and finds a purebred male and they sell puppies. Ned's not holding himself out as a breeder of purebred female Cocker Spaniels. And there's nothing in this example that suggests that he has some special skill or knowledge that would make him a merchant for puppies. So in this example, no. Let's say it turns out later that Ned, while keeping his lawyering job, expands his dog breeding activities considerably. He now owns several females that he regularly breeds and advertising and selling the offspring under the name of Spaniels of Springfield. Now in this case, he's holding himself out as somebody with some sort of unique knowledge and skill in breeding Cocker Spaniel dogs. In this case, Ned may be considered a merchant. Another example I kind of want to point out where things might get a little sticky between businesses. Let's talk about Ben & Jerry's. Everybody knows Ben & Jerry's. What do they sell? What's their good? Ice cream, right? When anytime you hear about Ben & Jerry's, right, you think ice cream. Ben & Jerry's is a merchant for ice cream. When you go to the store to buy Ben & Jerry's, you're buying ice cream, right? That's the end goal. But if you ever had the opportunity to tour their plant in Vermont, you could see how they make their ice cream. It's very exciting. And they go through the process of telling you where they get the ingredients and how they use the ingredients. And they try and, buy natural, buy local, and they try not to waste. And what I'm about to say next is not true of Ben & Jerry's. I'm just using this as an example. So, but let's say, because they don't like to waste, but let's say they have extra cream left over at the end of the day. They don't want to throw it out. So maybe they make a side agreement with another local business. Here, you can have our cream, our extra cream, or milk, whatever they're using to make their ice cream. The other business pays for it, and now they can go off and make homemade cheese or whatever that business is doing. That agreement between Ben & Jerry's and that other business for that excess of cream would not make Ben & Jerry's a merchant relative to that cream. That's not what they hold themselves out for. That's not, even though that's a contract arrangement between that other business selling that extra cream, that is not what they do business as. That's something outside the scope. Okay?